Urgency as a self-fulfilling prophecy. Emotions over school attendance. The case we looked at recently in Chase v. Chase is one of the many recent Ontario court rulings involving parents who are in dispute over whether or where to send their children in light of the COVID-19 pandemic. Decided in the final weeks of August 2020, it featured a mother who wanted to be granted sole custody decision-making authority in connection with their 10-year-old child's educational decisions, over the objections of the father. More to the point, the mother wanted the child to return to school upon its official reopening in a few weeks' time, while the father wanted him to remain at home until the governing school board's safety protocols around COVID-19 were proven successful, until leading health experts are able to offer more certainty using data from other children who are attending school in person. In addressing the parents' dispute, the court framed it as the first of many pending cases of this type, all due to be heard in the weeks leading up to the formal resumption date for Ontario schools in September. The Ontario court elaborated by saying, "This is the first of several urgent motions to be filed with the court since August 17th. And while without doubt there will be more forthcoming, there's been no case conference, no attendance at a mandatory information program as required by the rules. And it's unclear what attempts have been made by the parents to confer about the disputed issue. There is a common theme of all these cases currently before the court. Parents disagree about whether their children should attend in person or online. The upcoming school year will begin in the next 2 or 3 weeks, and for some students have already started. That choice needs to be made eminently. School attendance in the midst of a pandemic is a challenging issue for many parents and families. Unfortunately, for some separated and divorced parents, this is another battleground. One more arena where the child may become prisoners of war. The court noted that these motions were all brought on an urgent basis under the family law rules. That designation is confined to situations where the court is of the opinion that a situation is urgent or hardship exists. If that threshold is met, then the parties can proceed, thereby circumventing the normal family court rules that first require a case conference to be held. This led the court to make some important comments about what it called self-fulfilling prophecy of urgency. Cases where parents have essentially dragged their feet, then suddenly, only weeks or days before school doors are set to open, claim their matter requires immediate judicial attention. The court explained urgent as a self-fulfilling prophecy by stating the need for a court to address this issue on an urgent basis is a self-fulfilling prophecy, merely failing to resolve the issue from March till August, and voila, the test for urgency is met. In the normal course, this approach would not be tolerated. However, notwithstanding that parents create the problem, jump the queue, and should not have their matter heard without the following usual processes. The court's duty is to deal with these cases expeditiously. The child has a right to know the plan for the upcoming school year, and the parents need time to prepare for it. The court added that a better approach would be to resort to mediation with a professional or third-party trusted family member. There were also several other creative ways for parents to resolve the school attendance dispute, including first, enrolling the children in September, then revisiting the choice at a later juncture, and second, creating a small pod of children who could learn remotely together with the assistance of a parent or tutor. With chagrin, the court in Chase v. Chase noted that the parents in that case had considered none of these multiple options, and moreover had waited until mid-August 2020 to bring the matter to court. Nonetheless, in the interest of justice, the court proceeded to hear the substantive aspects of the parents' dispute, but not before uttering the following admonishment. The court noted in that case, and in all others currently before the court, that the mother and father have delegated the authority to make the decision respecting their children's in-person versus online attendance to the judge, who has never met the parents, who will likely never meet the child, and encourage parents to return to mediation as this process that empowers them to make these important decisions. Please like and share this video. You can subscribe by clicking the bell at the bottom. You can enter your comments at the bottom in the box below. We're going to endeavor to answer everybody's comments at the end of each week. Thank you for watching our video today. I'm Russell Alexander.